I have the honor of introducing Dr. Arnie Scheinwald, who is going to moderate tonight's opening session and who is also the president of AFCC. He is a psychologist in private practice with Riegler, Scheinwald & Associates in Harrisburg, Pennsylvania. He is a recognized leader in the field, has been the past president of ACR and AFM, does many things at AFCC. You've probably benefited from his work on the conference committees over the years, the task force on the model standards for custody evaluation, and many more projects.
So let me begin with my pointless introduction. The title of our plenary tonight is Utilizing Research and Practice, Family Law's Catch-22. As that name implies, the issue of why, when, how, and even whether to utilize social science research when assisting the court or some other family law situation is a very complex decision, and maybe more complex than you even realize. Besides the fact that more often than not, empirical research is not used to support recommendations or opinions made by individual mental health and legal professionals, questions often arise as to the relevance of the research, the quality of the research, and the correct application of the research. Is the individual who is presenting the research really qualified to do so? Do they offer a neutral, well-informed opinion for the court? Is it necessary to perhaps bring in a separate, neutral social science researcher to help the court understand research? These are all questions we're going to be looking at, and I think they're questions that leave a judge oftentimes scratching their heads as to what to do with this stuff. In this plenary, we are going to use a hypothetical case design to illustrate several different types of interactions in this case between the attorney and his client, between the attorney and mental health consultants, and between the judge and all the players in the case. We hope by using this, we're going to stimulate a discussion that'll lead us, if not to some answers to some of these questions, at least to an understanding of what the problems are. We have an illustrious group of professionals to help us here. And the way we, or shall I say I, decided to do the introductions of our professionals was for me to start and then let them introduce one another. So I'm going to start with Matt Sullivan, who I am first and foremost want to say has become a very good friend of mine. He is a very well-respected psychologist who is in the Bay Area at this point in time. He recently received the Joseph Drown Award, which is the highest award given by the California chapter of AFCC for outstanding contributions to children and families in California. You have probably read articles by Matt in FCR. He is on the editorial board of the Journal of Child Custody. He sits on the board of directors of AFCC, and he has served on other task force. So I'll let Matt then introduce Don.
To my left and your right is my colleague Don Eisenberg. He is a family law specialist who practices in Los Angeles County. He's in Long Beach, actually. And he specializes in child custody, difficult child custody, complex child custody cases, and does a fair amount of litigation in that regard. And he was a former president of the California chapter of AFCC.
To my left is the Honorable Diana Gould-Saltman. Diana is a hero to those of us in the family law community in California and especially in Los Angeles, because Diana is one of those rare breeds of a well-respected, certified specialist, fellow of the American Academy of Matrimonial Lawyers, who made her way to the family law bench where she sits in the illustrious Pasadena court, which probably has two of our very best and most respected judicial officers, the place where every lawyer really wants to be if they have a case that really needs to be decided well. Diana was appointed to the bench in 2010, and we in California are very grateful for that appointment. Diana?
And to my left, your right, is Dr. Marcia Klein Pruitt. Dr. Pruitt is a practicing mental health professional for the last 20 years, first in Connecticut, now in Massachusetts. She does couples counseling and consultation, father involvement consultation, mediation, parent coordination, collaborative divorce. She is a Jill of all trades in the mental health profession, it would seem. She develops co-parenting interventions and evaluates their effectiveness. She writes extensively for professional and lay audiences, having done the Partnership Parenting and Your Divorce Advisor. She does a lot of speaking engagements, and she trains people like me, judicial officers who need to understand what goes on in the minds of those before us.
I don't have anyone to introduce. I guess I'm the furthest to the left over this group. Interesting, because they're all Californians. I'm Massachusetts.
In order to understand this case, you have to have a fact pattern. So allow me to tell you about the family structure and the facts surrounding what we're about to discuss. We have a mother and a father, both of whom are over the age of 40. They have never been married, but they have a child who is now 14 months old. Court proceedings began in this case before the child was 1 year old, approximately around 6 months old. The child lives primarily with her mother, and as per a court order, her father has been spending 3 days a week with her, one of which is an overnight. It should be noted that each of these parents is, quote, good enough, a good enough parent who has availability to parent and who is committed to being a good parent. The problem is they don't get along. In her response to father's parentage action, mother includes her intention to immediately move away, completely across the country from father. Father, in his response, strongly objects to the move away and requests increased time with the child. His intention is to build an equal timeshare arrangement as it is determined to be developmentally appropriate. In response to the petitions, the court orders that a comprehensive custody evaluation be completed and that a move-away analysis be a part of this overall evaluation. Keep in mind that this case has been before the court for quite some time. In assessing the family, the evaluator discovers that mother has no compelling reason to move across the country other than that she feels she would be happier once she gets there. On the other hand, father refuses to offer a parenting plan if the child is allowed to move away with her mother. The comprehensive custody evaluation is completed, and the evaluator recommends that the child be allowed to move with the mother. However, the evaluator in the report acknowledges that it will be unlikely that the child will be able to continue to maintain a close psychological connection to the father, given the infrequent contact of perhaps only once or twice a month that the child may be with father. In the evaluation, the evaluator has applied a straightforward comparative detriment analysis, searching for the least detrimental alternative for the child. The determining factor for the recommendation is that mother is the historical and actual primary psychological caregiver to the child. The case is now set for trial, and all issues are going to be considered: custody, visitation, and move away, which is likely to occur about 1 month after the child's second birthday. We've now moved forward, so the child is a little bit older. So that's our case. What we're now going to do is we're going to hear from Don, who is Dad's attorney. And we're going to assume that he is meeting with his client. We want to understand what he's saying and what his thought processes are. Don, you represent this dad, and you've had for lack of a better term, a bad evaluation for your client, with that recommendation going pretty strongly against his position. You're going to have to decide whether or not to go to trial, whether or not to settle somehow. So why don't you start with kind of just sharing your general thoughts as the attorney in this case of what you're thinking about, where you're going to go here.
That this is so complex that I don't want to give an assessment of the evaluation. First of all, I'm not a mental health professional. I always think lawyers are the last people on earth who should be delivering bad news to their clients by the way of an evaluation. But that said, I think I would tell him that, I'm a longtime member of AFCC, know an awful lot of really capable people. Would he mind terribly if he allowed me to consult with someone in the mental health community who has the credentials to be able to give us some insight into this problem and see if there's anything that we might be able to do?
Is that a common process for you to think about, that is bringing in a consultant, or are you saying that this is a specialized fact pattern that would lead you to think that?
So, in my particular practice, it's not that unusual to want to have a consultant, often because there are high conflict, nuanced problems. But I think it's a wise idea anytime you look at a problem, you look at a report, it seems to be well written, but there's something about it that doesn't particularly give you everything you'd want to know. This report, right? The mental health professional seems to be concerned about the child maintaining relationship with her father. So there's certainly something that bothers the mental health professional. Great thing about AFCC, you get to run into all the best people in town. I'd call Matt Sullivan. I'm going to say, hey, Matt, got a problem case down here in LA that I'd like to know if you'd be interested in working on. It's got some interesting and peculiar problems in it. If you'd like, I'll tell you whatever you want to know.
Well, I don't want to know anything, so I think it's very important if I'm going to get involved, and it's a little unclear at this point if I do get involved whether I might become a testifying expert in the case or a consultant, non-testifying expert. But either way, it's very important that you said there's been a custody evaluation?
Yep, there's been a custody evaluation.
So just send me the custody evaluation, and I'll take a look at it and review it, and we can set a time to have a feedback session. And based on the feedback that I give you, we can sort of make a decision about whether the feedback that I give that you might think, or we might think together, that me becoming a testifying expert might be the best use of my role, or whether moving into or continuing in a consulting role, which would be non-testifying, working with you in a partnership, would be the best, or we might part company at that point.
I want to know, Matt, do you want just the report? I have all the raw data that's been given to me, of all the test data. I've got other reports. Would you like pleadings or any of that stuff?
Not at this point. So just send me the report, and we'll go from there.
Sure you won't let me bias you in any way?
Well, that's an interesting question you just threw in. I know you were joking around for us here, but why wouldn't you? So
there's enormous pressure on the part of attorneys when they first call you up to just download, just to front load you with all the information that they have, of course, based on who they're representing. Mm-hmm. And it's really important to bound that instantly. Otherwise, I think you do have substantive bias that's introduced right away.
Okay, so you would block that regardless of how he attempted to put pressure on you for that?
Sure, and I would use that to educate you, that you're going to decrease the effectiveness of my role if you tell me anything.
Okay, so you've had this contact. We're uncertain at this point if Matt's going to be a testifying expert, whether he's going to be just a behind-the-scenes non-testifying expert doing some litigation support of some sort, or just some consultation around settlement. We're unsure of all the possible roles that he could possibly play. So, Matt gets the report. You've read the report. Here comes the follow-up conversation. So, Matt, you get back to Don. You let him know you read the report. What happens now between you guys?
So, here's what I think. I think the report, first of all, the professional has really good credentials, knowledge and skills. The report was well written. The procedures are comprehensive. The findings seem to be pretty solid. I'll talk about those in a little bit. The analysis, I begin to have problems with. At the analysis point, that's when you sort of bring to bear the relevant social science research to make sense of what the findings are and to give your conclusions. And then obviously the recommendation should follow from those conclusions. So if there's a problem at that point in the work product, in the application of appropriate relevant social science research, you can have a major issue with and really a flawed report. And I think in this case, that's my concern, that there is not an inappropriate, but there's a lack of use and application of relevant social science research to the findings that, as I said, were pretty solid.
So what we're hearing now is that we have somebody who did procedurally a good report, is what I hear you saying. That there's nothing you found in this procedure in terms of following standard methodology that you would argue with in the report. Are you also saying that from what the evaluator did, their conclusions make sense? I'm not saying that the research was right, but just that in the way they presented their own stuff. Are you saying that that makes sense?
Yeah, I am saying that, and I think that type of inadequacy in a report is much more problematic. If you have problems in your procedure, if you have problems in sort of an analysis that's coherent, if your recommendations don't match, your conclusions, it's pretty self-evident. It doesn't take a lot of critique to let the court know that this was a bad report. But what we're talking about is much more difficult because if the court doesn't have literacy in social science and there isn't someone who is making them literate, then it looks really compelling.
Okay. I would just to kind of jump around for a second, since we said we'd do things. Diana, do you agree with Matt's statement that for most judges it becomes self-evident that other type of report is bad and the conclusions don't fit?
Well, in this scenario, I think that for most judges, if the procedural portion, the data gathering is all appropriate, the analysis is critical. The analysis is the one thing for which we have appointments of mental health professionals. By definition, I am not to order a custody evaluation unless there's something about the situation that merely putting on evidence wouldn't be sufficient. I need an expert. I rely on that analysis for the expertise. And just as by way of example, if I'm a new bench officer, and by the way, in family court, that seems to be the starting grounds for a lot of places to put their newest, right out of the block judicial officers, I'm not going to have that background. So what if I look at a report which on its face appears to follow the bouncing ball And as an example, if that evaluator says, well, all mental health professionals know that children under the age of 7 should be with their mothers per se, how would I know if I had no information about the research that was bad research? Because the conclusion seems to follow just neatly. So I'm going to be very resistant unless I'm given some other information to do something different than this expert has told me.
Okay, so I assume that's the problem and barrier and fear you two face. So keep your conversation going.
So
Go ahead.
the evaluator has said this is a very young child, which is a solid finding, that there's not a compelling reason to move. Remember, we're in California, so this is a La Mouget analysis. So if it isn't a malicious move, then the reasons become less relevant. But this is not a compelling move. We have a father who is both competent and available to provide care 100% if necessary. Both parents are, and it's been for developmental reasons. The timeshare is primarily with mom, so he has less of a timeshare, not by choice, but because he's actually acting in the best interest of his kid. He's certainly wanting more time, and now mom is electing to move, and moving at this point when the child is still an infant basically, to a geographic distance that will preclude the development and maintenance of a secure bond. So I think that the analysis that's done and the social science that is utilized is all about who's the primary caretaker. That seems to be the most salient feature, and that to not allow the child to move would basically necessitate a change in custody. So it's kind of an easy determination for this custody evaluator. I think the custody evaluator fails to look at other factors that we now know in the social science research that are relevant to that determination. That there is, from what I can tell, there may be sufficient detriment to this child because of 3 areas that aren't even addressed. One is that this evaluator didn't even look at attachment and the impact of relocation, significant relocation on attachment to both of the parents, most importantly the father. Secondly, the role of the father. I mean, if you basically blow this father's attachment out of the water, which is what this will do, what difference does it make? And there's no, we now have a lot of good literature about the importance of fathers, non-custodial parents, on the long-term adjustment, healthy adjustment of kids. There's no mention of that whatsoever. And finally, this notion that there's no compelling move, and so it's sort of not relevant. There's now emerging literature about gatekeeping and about a continuum of more restrictive gatekeeping, which isn't facilitating the bond, the relationship with a parent, to facilitative gatekeeping, which is important in relocation, even more important than if a parenting plan is local. So I think those are the major flaws, and with the court not having some awareness of that lack of application of relevant social science research, they're probably going to assume that this is a pretty slam dunk recommendation.
So Don, your heart is now beating faster because you've heard things that are good for you. What are you thinking? What do you want to do with it?
So, to the extent that I have some basic knowledge of the things that Matt is talking about, and I like to hope that I do, I'm encouraged that he's seen the things that worry me the most about this case and this relocation. So I think I want to know 2 things, Matt. Are you going to testify for me as an expert or not? And if not, what are you going to do for me, for my client? And the second thing is, If you're not going to be the testifying expert, am I going to be searching around for one of the usual suspects in LA, or should we bring in somebody who can really offer something that's unique and different and is going to make this court have to think about this problem?
Yeah, I'm thinking that I'm not the best testifying expert in this case, and that my role would better be served working with you and instill the attorney-client privilege to try and put together an efficient and effective presentation of the relevant social science research to the court. The reasons for that is, you have a few options to try and do that. One is that you can do it, right? You can, in your papers, in your filings, in your trial briefs, you can try and put this stuff out, and I can certainly help you with that. You can depose the custody evaluator and try and probe, whether he or she has even considered this literature, and you can obviously put them on the stand. That would be the most cost-effective. I think likely to be the least effective way to go.
I've already rejected that.
Oh, okay.
Well, let me stop you. Let me stop you both there. Why?
Because that never works for the lawyer. The most knowledgeable, effective, well-read, well-versed lawyer who comes to talk about the state of the literature and what the mental health professional didn't know, didn't seem to know, particularly a well-respected mental health professional in your community, is going to make the judge think that maybe he or she won't appoint that expert the next time, but you don't have another expert to counter it, so you're a smart lawyer, or you're a knowledgeable lawyer. So what? What do you leave me with? You leave me with a report with an infant child and a mother who's been the significant psychological parent. You're just not going to win with that.
Okay, so tier one is the lawyer tries to go after this himself, and what I hear you saying is that's not going to work, or your experience is that's not going to work. Tier two, though, is you going in as the testifying expert.
Right. So I could go in as a reviewing expert, and I think that's actually pretty effective when the issues have to do with that first level of analysis. Is it a sound work product procedurally? But I think where it's not going to be as effective is when you're trying to be the expert in the social science research. I mean, as a reviewing expert, I'm a generalist, and I'm not. So what's going to be missing in that is having someone who is really considered, one of the people who knows these particular aspects of research and has that kind of credibility to hold the judge's ear in becoming more literate.
So before we go to perhaps our superstar, social science researcher, I want to go to the judge. You've just listened to this analysis. Do you agree with that? Do you agree that the lawyer can't put it across to you in a way that's going to sway you? Or even that the generalist may not be able to sway you? And I guess maybe a preliminary question is, do you give a damn about the social science research anyway? So, which might be an important question to answer.
Well, number one, if I'm a good judicial officer, I have to make my decisions based on evidence. And as best I understand, if the most Don can do if he's by himself without a countervailing expert is to chip away at this one, all he's doing is taking away evidence for me to consider. He's not giving me something to consider. At level two, where I've got a reviewer, again, if I have a reviewer who's merely chipping away at the evidence I had before me, it doesn't leave me with something left with which to make a ruling. A reviewer might, however, be able to, by way of example, say, there's some good in this report. There are some things you can retain without coming to the same conclusion that this expert did, in which case then a reviewer might be able to give me entree to doing something else. If I've got somebody who can then give me that something else, then I think you've given me something.
Okay. Anybody want to add anything to that, by the way?
Yeah, I think another distinction is that reviewing experts tend to be perceived more as hired guns, that they are brought in by one side to critique or to support. And I think there's going to be a differentiation if you use a social science researcher, in that there may be a perceived less bias, more neutrality, yeah.
So you start thinking about this third tier, which is now to bring in another expert, right, who is this social science expert. So talk about that. How do you guys decide to do that?
So if I can chime in just 1 second, I think the other problem with having the reviewing expert in the kind of facts that we've set out in this hypothetical, the reviewing expert is going to be in real trouble on cross-examination. I mean, this is an infant child of a never married couple where the mother has basically had the child, if not predominantly, except for this court-ordered visitation, virtually all the child's life. What possible thing is the reviewing expert going to be able to testify about ultimately, should the child move, should the child not move? What he's going to be doing is talking about the social science research, but he's completely vulnerable, it seems to me, on cross-examination for when the other lawyer is just hammering these are the facts. Can you disagree with that conclusion? If this is so, can you disagree with that? So it really, I mean, you present a fact pattern, thankfully, that leads us to really needing the social science piece as a separate independent piece. I think that's what I'm getting from Matt, and I think that's how our discussion goes, okay? If not you, then whom?
Well,
Right.
I'm gonna let you explain that to me, because I don't know if you all got it, but it would seem to me the way you just described the vulnerability of the first reviewer, why wouldn't that same vulnerability be there for the social science expert?
So I think one of the things we want to do here, and maybe it's perplexing for the lawyer for sure, because I want more than anything to be able to have my client's case decided on the best, clearest, and most truthful basis. Right? I'd like to stop the move, but if I can't stop the move, I at least want the judicial officer to have everything that could possibly be had that would be good science, good foundation. And if I can't use the other two successfully and get the good science before the court, I mean, Matt, what do you think? What should we do?
Then I think you want to get the most the best possible social science expert in the areas of attachment and the implications of attachment for parenting plans and ultimately relocation. I think you want to get the best social science researcher who can articulate, the state of the literature on the role of fathers and its relationship to the long-term adjustment of kids. And you want to get the best social science expert to talk about gatekeeping and how to understand better what restrictive versus facilitative gatekeeping is, and present that to the judge, again, without even knowing the facts of the case, just to bring that judge's awareness of these issues.
Again, you're not going to let me bias this person?
Again.
What is the story here? Okay, well, we've been to AFCC conferences. I know a few people who I think might pick up the phone. Have you got anybody in mind?
I've got somebody in mind. And she is the best. And her name is Marcia Klein Pruitt.
Oh, right.
This is a hypothetical, right? Just checking.
Hypothetically, you're the best. That's correct.
Doesn't she have that
Well,
new co-parenting book out?
I have one more question for Your Honor. You've kind of had this fortunate ability to be a stalker and listen in on the conversations going on here. When it comes to social science research, I mean, is that going to make a big difference to you here?
Well, I would say in this case, it might be useful. My concern would be that it needs to be used for exactly the reasons that are being described here. There should have been some information about that in the report. It's missing. So somebody needs to fill me in on that. Or if the evaluator in this case, as was not the case, had put in research and it was simply misstated, misquoted, leading me to the wrong conclusions, then someone else would have to come in to set me straight or let me know there were at least two sides to this coin. So under those circumstances, it's appropriate. It doesn't mean it's appropriate in every case. And so the garden variety case, if there is such a thing, wouldn't necessarily be the appropriate time to always line up a series of experts or have a social science researcher come in, nor could anybody afford that in the garden variety case. But in this case, I think what you'd need to do if you're going to do something unusual, because it would certainly not be the usual circumstance that somebody puts a witness list in front of me as saying, we have an evaluator, we have a reviewer, and by the way, we have a social science expert we want to put on. You might need to explain to me why that's necessary. In this case, I think you'd be able to do that.
Well, let's see. I'm not so sure yet. So you're going to make contact with Marcia. So you do so. You call Marcia and you say, hey, have we got a deal for you? How do you lay this out for her? What's going on? So why don't you start kind of a conversation with her about her involvement in this and ultimately her preparation for testimony in this thing?
So I think if I'm lucky enough to get Marcia to reply to an email, and she usually does, that I've got a complicated case that I think really needs a quality researcher to give us some input so that the court can have genuine science, real data, something that it can rely on before it makes a decision. And I've hired Matt Sullivan as a consulting expert. Is there any chance that you would be interested in being a real neutral, just testifying about the research that we would give you? Matt will help to prepare you, and if the answer is yes, I'll set up a conference call.
So I'm seduced by the real neutral thing. I think my first response is, I'm not really interested. I'm an academic. I've made my life in this field by staying out of the courtroom mostly. I don't ever come in on one side. And you've got Matt Sullivan. He's great. What could I possibly add to that? This seems like overkill.
You know, if I can convince you, Marcia, the problem that I think most lawyers are confronted with is they see the need to put on this kind of data at the trial court in a unique case like this, but they don't do it either because they're afraid that they can't get an expert like you, or they can't get the evidence in because you're testifying as a neutral and not about the facts. But then when it gets up on appeal or when it gets to the Supreme Court, then all of a sudden they're looking for the social science data because no one gave it to them at the trial court. You know, I've been doing this for years and years and years. I do not want this case to go up on appeal, missing a key social science piece, and not have had the opportunity to have the best expert available, put on that social science data, and tell this judge what good science looks like. Wouldn't you please?
So the sell is that this case may make new law. It's not just your run-of-the-mill case, but your involvement could be something bigger than just...
The seduction. Every good story has a seduction.
If you want to seduce a social science expert, you tell them they have a chance to change the world with research.
The more grandiose, the better.
Absolutely.
Yes?
California is practically the world to a Massachusetts person.
See, one of the other advantages in doing this, as I think through it, is that a judge is going to be very resistant to throwing out the whole report. If you tell me this report is trash, I'm going to say, oh my God, this family has just wasted 6 months of their lives and all this work and all the difficulty they went through to go through it, and now you're giving me a reason to say, no, wait, we can use a scalpel here. There may be something that this expert can assist with that may make salvageable some of what's gone on. The other thing is you're telling the judge, if it's salvageable, you were not a complete idiot in appointing this evaluator in the first place. And psychologically, that may be something that gets you through the door.
Okay, so what I'm hearing here is that the attorney is already strategizing at another level. We haven't talked about that, but you're saying I'm already thinking appeal. That there could be appellate issues here, and it could form new law and all sorts of interesting stuff. But it all has to do with your advocacy.
Oh, yes. I mean, you have to assume, right, what's the worst case scenario and the best case scenario? Best case scenario is no move. I know what the other side's going to do if the judge says no move. That appeal's dead bang. Maybe I won't be able to, maybe I won't be able to afford to, but if the judge does anything other than a straight out, move away, custody to mom, maybe I've got some, particularly if he doesn't decide, if he doesn't consider the research, and I've got a real flaw at the center point, and I've got Matt who's telling me that there's some fundamental things that weren't done, which I am hoping or thinking might be the case. Your job as a litigator, and all the litigators out there know, is to win it in the trial court. But if you can't win it in the trial court, it's at least feels like malpractice, even if it isn't, if you don't put everything before the trial court that would have to be considered by the Court of Appeal if it goes to the Court of Appeal.
So what we're hearing is social science information, research, facts of this case serves a different purpose for everybody in the case. I mean, for Marcia, it may mean she gets to change policy and law at some level that's helpful for kids she cares about in general. For the attorney, it's setting up the pieces of a potential appeal and hopefully winning at the trial level. For the judge, hopefully it's very educational and is going to allow her some other directions in this. You think anything else? Any other way?
I'm just in it for the money.
We knew that from the beginning. No, but anybody else see any other aspect of this I'm missing?
Well, going back to Marcia's philanthropic leanings, everything you teach a judge in this case is knowledge that judge will have for every case thereafter. So even if it's not in the Court of Appeal, you've now given that judge a tool that judge will have for every future case.
And we all know judges talk to one another. So it never hurts to have a knowledgeable judge.
And I guess at a macro level here, not just being the moderator, is we affect the education of judges every day when we do this, and we can either give them bad information or good information, bad education or good education, or no education, which is probably better than bad education, but not very helpful. Okay, so how do you structure this? How do you do this with Marcia?
Well, my role is to bridge these two. And that depends on how much on your side you are literate about these social science issues, because if you're well versed, you don't need a lot of me. And on your side, the bridging is more about what kind of forensic experience you have, how comfortable you are in the courtroom, and you know that can be, you can be well versed, and then you don't really need me as a resource. And if not, either your anxieties or your skill in that regard, I may be a support to. So I certainly provide that liaison function. Mm-hmm. And then I think, you know, either you or I need to ask her to testify about the relevant social science studies in these particular 3 areas. So to say, you know, this is what we'd like from you, Marcia, that we'd like you to present, you know, a good, balanced set of, you know, basically teach about the state of the literature and attachment. If there is literature that relates to long distance, that'd be great. Again, move back to the role of fathers and move through that literature and talk about gatekeeping to the extent you can. And that would be really the preparation for you to then be deposed by the other side, potentially, and examined and cross-examined if it went to trial.
You know, I don't think that any lawyer, or I don't know of any lawyers, at least in my community, who, having gone to the effort of getting Matt involved, would then decide that I would want to take on doing Marcia. For one thing, the temptation to try to tell her all the facts that would shade her to my side is very, very great. Secondly, I think there's an awful lot of trust issues that go on here. You know, lawyers, I like to think AFCC, you know, prepares you to know a lot of current data, a lot of what's going on current. But very few of us have PhDs. I for sure do not. And so we're not very deep in the material. And I would think it extremely foolhardy if I were to try to prep Marcia on what it is I want her to testify to about these areas, particularly if I want to keep her completely neutral. By having Matt there, I think it really frees me, assuming I do trust Matt here. So I trust Matt, I trust Marcia. I'm going to sit back and try to learn, because I'm going to have to be the guy that's going to have this very difficult moment trying to present this data. And it's not going to be easy to get an expert who isn't connected to the case to testify in this case, I think.
So let me get this straight. You're going to hire Marcia, and you're going to say to her, you know nothing about this case. We don't want you to know anything about this case. We want you to go in and be Professor Pruitt and give a seminar for the judge on the research. And, you know, let the pieces fall where they may. How many of you know attorneys who are going to do that? I mean, that's kind of out there. Do you buy that, Marcia?
I'd have to if I'm going to take the case.
I'm stymied. Because I thought you have an ethical obligation to zealously advocate for your client. She could go up there and kill your whole case.
She could.
Well, I think that's where, as a consultant, I have to be pretty sure what she's going to say about the social science literature.
So what makes you so sure you know what I'm going to say?
Because I've read everything you've ever written, and I've gone to your AFCC workshops and plenaries, so unless you say something different, in which case, yeah, we're toast.
Am I really that predictable? You know, one thing about this field is that the longer you work in it, hopefully we change. And I'm wondering...
But I'm just asking you to, you can change, but the studies as they are speak for themselves. And your job...
How I'm going to talk about them, really.
Well, we know you did some longitudinal research, so you're not going to, in 15 minutes, reverse yourself on what you studied for 5 years and wrote up in a journal, we hope. At least I do.
Yeah, and I know what you're going to say about gatekeeping, and I know what you're going to say about, those issues. So for me, there's not a lot of risk in having Marcia provide that education, so that the judge has a different lens to look at what are the findings of the custody evaluator. That's really the hope.
So besides the appeal of changing law forever in the land, what's going through your head, Marcia, with this whole thing?
Well, one of the things I'm thinking about that's interesting is, as a clinician, I often work with the mom, I've worked with the dad, I've worked with the couple. Sometimes I've only worked with the kid, and I never know what I'm going to say, so obviously no one else could. It's a really different role to come in on the social science expert piece. Both of you are saying you really trust what I'm going to say or how I'm going to say it. And that means that they're really saying to me, don't come in with your clinical head, come in with your academic research head. And so first thing I'm thinking is, can I do that? Because I'm all of those things. And I think that's part of what makes me a good researcher, is that I'm a clinician. And yet I'm going to have to keep those really separate here. And that's hard. The same way you're worried about whether you're going to overstep what you want to do, I have to think about whether I can play that role. Because I'm a mental health person, right? I want to help. I want to do good. And that's very powerful. So I'm really thinking about, can I separate those parts of myself out? And I'm gonna try this case. Try it, not be a trial, but I'm gonna try and do it because I think, one, that the risks are smaller than the opportunities in it. And I do trust that I can separate myself that way. I've spent a lot of time thinking about this stuff, and I know it, and I know why it's important, and I think it's important to convey it. And that conviction is what's going to make me probably agree to help these guys.
And it's what's going to make you a compelling expert.
Agreed.
So is there anything special in this preparation of your witness we should know about, especially around social science research?
Well, what I was going to say is that obviously if I'm doing some of that, walking her through her testimony, I'm potentially just as susceptible to, leading you to, the issues that you were talking about, Dawn, in terms of having a stake, in the outcome. So it's really important for me to be mindful of not leading her any more than because it's gonna impact the neutrality and bias her.
So you're saying you're going to try to prepare her for testimony without giving her any hints or direction as to what your side is really about in this, other than you represent that.
That's right.
Well, Marcia, what do you think about that?
I'm blind to the facts. I'm not deaf and I'm not mute. And I'm pretty good at what I do. So I'm going to know in about 5 minutes all the things they're not telling me. And I know I'm going to know that. Technically, I don't know it. And I'm going to keep trying not to know it. But come on, right? I know sort of at least what direction they're going in. So I think what I have to trust at this point, and that I have to have a clear conversation about it, is this is the boundary, neither of us are going over it, and whatever I'm thinking in my head, I'm keeping over here, and you have to keep that over there, and and we have to really stay focused. And if he doesn't go over his line, and I don't go over my line, I think we can do this.
Diane, you want to add something here?
Yeah, in the same way that there is no perfect child custody evaluation, there is no perfect witness. So I think you could anticipate that a good cross-examining attorney who is going to be taking Marcia en voir dire, should she get up and testify, will begin with a question, who have you talked to about this case and what did they tell you? And to the extent that she says, nobody's ever told me anything, I've been in a soundproof booth over here, I have no idea what this case is about, she won't have credibility. To the extent that she says, I needed some limited information to understand the dynamic of the issues before the court, but here's what I don't know, she's enhanced her credibility as a witness before the court.
So in a sense, you're saying the same thing Marcia's saying, that you are also not, which one weren't you?
Blind to the facts, but you're not deaf and you're not mute.
You're not deaf and the other things. You're not deaf and the other things either. And so if she's being called as their witness, don't you make some assumption that she's going to have some bias going in there?
That may be sort of my opening gambit as well. I'm saying she's on their witness list. She's not my neutral expert appointed. But one of the ways that she, I assume, will be able to address that and give me a little more confidence in her testimony, in addition to my seeing what her qualifications are, is by her explaining the issues and explaining the literature, perhaps on more than just one side of the issue that benefits the client who's hired her. If she's done that, then they're confident that the literature, when taken as a whole, is going in a direction that will be favorable to their client, then I'm going to feel comfortable that what she tells me has credibility because she's not just giving me one side of the literature.
Let me ask a different question, just popped in my head that none of you are prepared for. We're talking here, it sounds like, a case where you recognized, Matt, in our hypothetical case, that you are recognizing that there's just not literature that's being addressed at all, research being addressed at all, whether it's attachment or gatekeeping or father involvement, whatever it may be. Oftentimes, in the real world, what we see is cherry picking of data, right? Where the research is mentioned, but it may not be complete. If you were called in that situation, if even at this tertiary level of this social science purist researcher called in, how do you not sound like you're doing it from the other side? I mean, what do you deal with? How do you deal with cherry picking in that situation? Because that, I think, is in some ways even a more common problem we face.
I think you deal with it in the same way, that you point out that particular piece, that study, doesn't represent either the totality of the research in that area or maybe even have been transcended and disproven. So I think that's a pretty potent kind of introduction of social science research to change what may be the court's sense that the expert's opinion is a sound opinion.
If that's what had been presented to you, Marcia, that there had been a misuse of research, would you still have involved yourself in the case?
Probably yes, because that is one of the things that happens most often in the field that is most detrimental and causes these things to get debated up and back endlessly. So I would probably be riding my high horse to go fix that problem.
So that would appeal to that higher order need of yours also.
Yeah, it's a pretty big strain.
Yeah. Anybody else have any comment?
Well, I think that's one of the reasons why a conference like this is so important, is this is becoming very common. There's a much more complicated fact pattern, but that cherry picking pattern comes up all the time in move away cases of infants and overnights, young children, all the never marrieds versus, I mean, it's just rampant. Cherry picking on attachment research, cherry picking on gatekeeping, all of that kind of stuff. We see that all the time, and it's very hard to get the social science research in because you pick someone in your community who you think is a very capable person, and the court sees them as just your hired gun on the other side, and it's tough. I think that's a real difficult problem for the legal system and for the lawyers in it.
Diana, how does this all work from a judicial perspective when you have to put this social science research against the law, and what your boundaries are with respect to your decision making?
Well, that becomes a little bit tough because, frankly, I would love Marcia to be giving this information to the legislature so that they could then craft the law consistent with what social science now shows us.
Or the appellate court.
Well, even not through the appellate court. I would love for there to be actual legislation that says, rather than, some legislator, which certainly happens in my state,
they are blind and deaf.
Hearing from a disgruntled constituent, I had this bad deal happen in my divorce case, I need the law changed, and you get the Angry Moms Club, the Angry Dads Club up in, the state capitol arguing for a new change in the law, and it happens. Now that becomes the law that I am bound to apply because that is my sworn duty. The other thing is, though, I have an obligation to be looking at the best interest of the child. So to the extent that, by way of example, I have a presumption I must apply that has to do with move-aways, which in California I have, or a presumption I must apply with regard to domestic violence and what rebuts it or doesn't rebut it, it may very well contradict the other statutory obligation I have to take in the evidence and address the best interest of the child. So it becomes somewhat of a conundrum. I guess this would be the issue of whether or not it's appropriate for trial court judges to be activists if the law is clear. The law is rarely that clear, but once in a while it is, and it creates problems.
You want to say something?
Yeah, it's not exactly on this point, but as I'm sitting here, I'm thinking of one other layer of complexity that's important to add, and that is I'm increasingly aware that a lot of people can talk about research and what makes it good and what doesn't. And I'm aware that one of my dual roles is that I've done a lot of the research. I've done a little bit of the research on young children and family law, but I also know I've done the world's largest study and the only randomized controlled study of father involvement, 850 families longitudinally, cross-culturally. And that, knowing I've done that, puts me in a very complicated dual role as a researcher. It's hard to say I'm being neutral and not cherry-picking and not admit that I have my own biases over time and my own, love from what's coming out of my hard work. And so, in addition to all of this, I have to make sure that when I present it, I am both clear about where I'm coming from and as honest as I can so that the judge really trusts where I'm coming from, but also aware that I may be unbiased in this case, although that's difficult because I'm increasingly aware of the facts, but I'm even more not unbiased in my own field. Mm-hmm. And it would be disingenuous to suggest anything else. But
I promise I'll ask you a question that will allow you to do that, so you won't feel too bad.
So, that's very kind of you.
I feel so much better already.
The question, I guess, that we should all have at this point is, in this case, there are 3 experts involved. There's the original expert who does the custody evaluation, and that costs a ton of money. There's the non-testifying expert, that costs a ton of money. There's the social science researcher, who obviously charges much less because she's just cares about the good of the universe, but still costs money. So how does a normal family do this in court? Most families
there are
don't.
No normal families in court.
Well, how does
The non 1%?
yeah, that's good. The non 1%. How does the non 1% do this? How do we present this research? How do we educate the court when people can't afford to do it? I mean, we're asking the clients, it seems to me, to pay for the court's education.
It's true.
That's an interesting. I could run on that one. Welcome to the Tea Party. You educate the court. No, I'm glad I did it again. What do we do? How does it happen? How can we do this?
Well, obviously sometimes you can't. And when I was sort of laying out, well, you can do it this way, you can do it, that's going to be less costly. And and then the next tier of having another expert is more costly. So there is a reality to the resources of the family in that case that may indeed preclude what we're talking about, which is making the court more literate in that case about social science research. That's one reality.
Mm-hmm. Anybody else got an idea?
I think that the example that we use is like the example of any hypothetical that ends up in the Supreme Court. There are always the bad cases that make bad law. There's always these extreme cases. But what we try to do, I hope, is that we see from this kind of a hypothetical that hiring a consultant can be very cost effective. It's way less costly for my client and gives much better information for me to hire Matt at the beginning after getting the evaluation than it is to go out and hire another expert who I think is going to be ineffective, or trying to prepare it myself, which I think is going to be ineffective. And maybe Matt has some good ideas that I'm going to be able to take to my client. I think that piece is one piece that we should take sort of in isolation and look at how that can be effective, and he can educate me on the research, and he can help me deal with my client on those issues, and maybe make a parenting plan that is the best possible plan if I'm going to settle the case. On the other hand, if I'm really going to have to go to trial, it's presumptively going to cost a ton of money. Somebody's hired me, and I'm not free either. So if I'm going to go to trial, and you're telling me I'm going to be a zealous advocate, is this the moment that I stop, or do I go, all in? It's the big poker game. And even if I'm doing something other than Marcia, there are lots and lots of talented people out here. It's the idea that we can present that social science research, difficult, but doable. And that then if that's the piece we do, and there's a lawyer out here who knows enough to be able to do that, well, more power to him or her, and go right to the research and put that on and educate the court. That will work. Because giving up when you've got bad science, the thing that worries me is to give up because there's junk science and we feel we can't do anything about it. That's the place most lawyers really hate to be and never want to be, and will do anything to avoid.
Well, just to some extent, the information that we need to get across by way of social science research isn't necessarily to a judge. That's only the last resort. Once you've gotten there, you've had lots of other opportunities for the case to resolve. Ultimately, it's the parents that need the information. It may be that the point in time when that information is available to them early on by way of brochures or other things that give them some rudimentary information about appropriate parenting plan options for children at various ages, they're not ready to hear it because they're still invested in their own pain and their own personal dynamic, and by the time they're ready to hear it, you find yourself in trial trying to convince a judge of this. It may be that giving them more opportunities earlier on, to the extent that the parents can be ready to hear it, if they knew what she knew, they may be making different choices, including choices other than litigating the case.
I just wanted to add that I'm aware when I do these cases that especially when I'm deposed, I try and respond to the questions in a way that opens up settlement possibilities. And I try to present the research not in just a, here it is, objective way, but in a, here's what research tells us about the risks involved in this kind of action, letting mom go, this kind of action, not letting mom go. Here are the risks in all the directions. And there's a way to maximize the touch points for healthy development of children. And I can tell you how the research gives you actually more touch points than you may be thinking about in this case. And so I use coming in as a chance to shut down a trial. This hypothetical's been going on, what, 2 years, a year? I mean, that's way too long. So that's partly how I'm going to, I think, be more effective and move this financially forward.
So what is the opportunity they all missed in their explanation? Get educated at AFCC conferences.
Absolutely.
I mean, clearly, at every level, and I do mean, rather than just plugging AFCC and making Peter Salem really happy now, I think that we have an obligation to educate ourselves about how we present research and understanding what good and bad research is, and really, if we're going to get involved in a case, make sure we understand the breadth of the research that's there, but then also serving a role of educating at a whole other level, attorneys and judges and parents around this. I think that may be the only other place we can go with this when there are limited resources. So I think our time is up. I don't know. We may have time for a couple of questions.
It's an excellent question. What I need is evidence. And so that was exactly where I was going. If the original expert's information was some evidence, and the information I get from a neutral is not giving me new evidence, it's giving me information, but it's not giving me evidence, somebody has to tie her research to the facts that I had in that evaluation. It may be that third person's going to say, here's the connection, here's why you can go in this different direction based on the research that we have and the facts of your case. You don't need to follow the path of the original evaluator. Here are other options for you.
How do you get that, though?
What's that?
How do you get that, though? You're going headlong in. You've already had a custody evaluation.
Yeah. I think he's proposing a different approach, and there are different approaches. So I would not argue with that. Question over here. Oops, sorry.
I just am really concerned.
Yeah, Mary, I don't think that we characterized Marcia as neutral. She's a social science.
Well, I think there was that characterization to keep her as neutral as possible.
To keep her as neutral as possible.
I think the problem that's faced from a strategic standpoint, and this, I was trying to ask questions about this and didn't get there, but the problem that I see that they had in this hypothetical is how do we get it across to the judge in the least biased-looking way? In the sense, I don't know, that may be a lot of words, but it's kind of like Matt would look more biased than Marcia would.
How do you sell it? I mean,
how do you sell it? And I think,
how do you sell
so
the
they thought going to a different level kind of did that. Let me go to another question. Go ahead. Did you still have a question, Larry?
I was worried about, when you talk about from a legal perspective, how Marcia's testimony, I'm not going to end over like a dollar projection as an expert.
It's a problem, I think. I think that's a very hard piece of testimony to get in. I think it's difficult to convince a judge, maybe Diana should speak to this, difficult to convince a judge that an expert who is just going to testify about the research is relevant to the facts of this case. I think probably what you have to do is convince the judge that if he or she relies on junk science, he's going to be in a lot more trouble than he is or she is if they're going to if they listen to what the empirical data really suggests about the things that they don't yet know, and that they'd like to avoid that in this case. But that's a tough problem, I think.
See, I don't think it's as tough a problem as Don thinks. I don't think it's an issue of Dober, and I will tell you I'm not in a Dober state, so it may be for judges that are. But I'm in a Kelly-Fry state, and I think that the component that Marcia's testimony is providing is like a piece of Dober. So I don't think that somebody needs to be able to pass a Dobert or Kelly-Fry test to provide a piece of it. They'll need to make a connection, they'll need to have the other components, but that's what the custody evaluation portion is. So I don't think that's going to be the problem. The relevance may be the problem, and I think in order to get past that hurdle, to get to that point, you've got to show the deficiency in the original evaluation, and that with this extra component, you'll have a complete evaluation because you'll have the social science component that then makes relevant the analysis. That's what it was lacking.
Your Honor, I must cut you off. Our time is up. So I thank you all for joining us tonight. Now you can go enjoy the reception. Thank you, everybody.